Welcome to this comprehensive explainer. Today, we're going to unpack the Canadian Constitution. And we're not going to look at it as some dusty, old, boring document, but rather as the living, breathing operating system of the entire country. Truly, whether you're studying law, getting into business, or you just want to know how your daily life is governed, understanding this framework is absolutely essential. We're going to break down these complex constitutional principles so you can clearly see exactly how political authority is distributed, and most importantly, how your democratic rights are protected. So, here is our roadmap for today. We'll be covering the Supreme Canadian Rulebook, building the nation, the branches of power, federalism and divided powers, settling jurisdictional turf wars, and finally, rights, rules, and reality.
All right, let's jump right into Section 1, the Supreme Canadian Rulebook, which is the very foundation of law.
Now, you might be wondering, what exactly makes a constitution the ultimate authority? Well, we have to recognize that without this bedrock foundation, government power could easily become unlimited. It could become totally arbitrary. And that is exactly why Canada operates under the principle of constitutional supremacy. In fact, Section 52 of the Constitution Act of 1982 explicitly states that the Constitution is the highest law in Canada, period. Every single law passed by any level of government has to align with this rulebook. If a law violates these rules, say by infringing on your protected freedoms, the courts have the power to literally strike it down. It is the ultimate legal safety net for all of us. Moving on to Section 2, building the nation. Think of this as coding the operating system. You see, Canada's rulebook definitely wasn't written overnight. Long before European settlement, Indigenous nations already had highly sophisticated systems of governance. We're talking complex decision-making councils and rich oral constitutional traditions. Then, of course, came the colonial era, which brought a whole mix of British and French legal traditions to the table. But a massive milestone hit in 1867 with Confederation. This was driven by economic needs, defense concerns against American expansion, and a real push for national unity. The British North America Act essentially created the Dominion of Canada. But here's the crazy part. We didn't actually gain full control over our own rules until 1982. That's when Canada patriated its constitution from Britain, meaning we finally, at long last, had full control over our own constitutional amendments. Which brings us to Section 3, the branches of power. This is the hardware of government. Just like a well-designed machine, Canada relies on three main branches: legislative, executive, and judicial. And they balance each other out to ensure no single entity gains absolute control. First, you have the legislative branch. This is Parliament at the federal level and legislatures at the provincial level, and they are the ones who actually make the laws. Next is the executive branch. Think the Prime Minister, the Cabinet, and the Civil Service. Their job is to administer and implement those laws. And finally, the judicial branch, headed up by the Supreme Court of Canada. They interpret the laws and ensure everything complies with the Constitution. It's a brilliantly designed system meant to prevent the concentration of power. Now for Section 4, Federalism and Divided Powers, or as I like to call it, distributing the workload. What's really fascinating here is how the Constitution Act of 1867 literally split up the national chores. Section 91 grants the federal government power over broad national interests. We're talking defense, banking, criminal law, and the postal service. Meanwhile, Section 92 hands provincial governments the power over more local, regional matters, things like education, healthcare, and what they call property and civil rights. This federalist system is pretty genius because it allows for national unity on the big stuff while totally preserving regional autonomy, so provinces can create policies tailored to their own unique local needs. To see how this actually plays out in the real world, imagine you decide to open a local bakery here in Canada. You're going to rely entirely on provincial powers under Section 92 for your employee contracts and your local building permits, because those fall under property and civil rights. But wait, to get your business off the ground, you absolutely need federal powers under Section 91 to secure a bank loan, since banking is strictly federal. And later, when your bakery blows up and you want to start shipping your famous cookies across the country, you'll be relying on the Federal Postal Service. So the Constitution is quite literally regulating your daily business operations from day one. Okay, Section 5, settling jurisdictional turf wars. How do we resolve system errors? Because federalism can get pretty complicated, right? What happens when these two levels of government inevitably step on each other's toes? To settle these turf wars, the Supreme Court relies on three diploma-level legal doctrines. The first is peace, order, and good government, often just called POG. This is a residual power letting the federal government step in during national emergencies or to fill in gaps not explicitly covered in the Constitution. The second is paramountcy. Basically, if a valid federal law and a valid provincial law directly contradict one another, paramountcy acts as the ultimate tiebreaker. The federal law wins out. And third, we have the double aspect doctrine. This is used for shared issues where both levels of government actually have a totally valid reason to get involved. Let's look at a real-world example of that double aspect doctrine, the environment. The word environment isn't specifically assigned to either Section 91 or 92, so it can be regulated federally when we're talking about broad national environmental protection. But at the exact same time, it can be managed provincially when it comes to regulating local natural resources, like Alberta managing its oil and gas, for example. Both governments are legislating on the exact same broad topic, just from completely different constitutional perspectives. And that brings us to our final chapter, Section 6, Rights, Rules, and Reality, Protecting the User. Here is where we look at the software upgrade that directly protects you from government overreach. Added during patriation back in 1982, the Charter ensures that whether you're expressing your personal opinion, moving from Halifax to Vancouver for a job, or seeking a fair trial, the government simply cannot infringe on your human rights. It protects fundamental freedoms like religion and expression. It secures democratic rights like voting, mobility rights, legal rights against unreasonable search and seizure, and crucial equality rights under Section 15. This was a massive shift for Canada, moving us to a system where individual rights are fiercely protected by the absolute highest law in the land. Now you might wonder, if society's always changing, why not just update the Constitution more often? Well, the general amending formula requires agreement from the federal parliament plus 7 provinces that make up at least 50% of Canada's total population. We call this the 7/50 formula. And honestly, it makes it incredibly difficult to alter our constitutional DNA. But that is entirely by design. It prevents any single region or just a temporary government from making arbitrary sweeping changes to our supreme law. But despite being an old rulebook, it has to constantly adapt to modern realities. Today, the Constitution serves as the neutral battleground for massive contemporary debates. I mean, how do we regulate climate change when powers are divided? How on earth does a 19th century document handle 21st century digital privacy? It is also the critical legal framework for the vital work of Indigenous reconciliation. Actually, Section 35 of the 1982 Act officially recognizes Indigenous and treaty rights, which is actively driving current, hugely important discussions on self-government and land claims. So, I want to leave you with this thought to ponder. As our world rapidly changes, with crazy new technologies and shifting global pressures all around us, is the ultimate rulebook flexible enough to handle the challenges of tomorrow? Understanding these rules isn't just about passing some law exam. It's about understanding the very forces that shape your business, your rights, and your everyday life in Canada. Thank you so much for watching this explainer. If you found this breakdown of the Canadian Constitution helpful, please drop a like on this explainer and definitely subscribe to the channel so we can keep making complex topics easy to understand. See you next time.